a major development. It marks a tectonic shift in the debate between India's national security, the need to, of course, safeguard it, as also, of course, the need to safeguard human rights and free speech. Those who are concerned about human rights, free speech, freedom of expression can breathe easier. That's because the centre has introduced safeguards that will make it difficult for governments to misuse the draconian colonial sedition law. In the course of a monumental hearing in the Supreme Court, the Modi government told the three-judge bench that the law will be revised but not scrapped so as to deter crimes against the state. In fact, the Modi government has issued an order that revised the procedure to be used when applying the law against India haters or those that are waging war against the Indian state. Satisfied by the centre's assurance, the Supreme Court has passed an order and also declared that it will give the government till July to implement the revised guidelines. Let me first take you through what some of these guidelines will be. So the FIR involving Section 124A will be registered only if an SP level officer is satisfied. So that is very, very important. Implication: no blanket stay on filing of sedition cases. That's what the government has now decided to do in keeping with a large number of precedent-setting orders that had been passed in some years back. So what do we know? FIR involving Section 124A will be registered only if a superintendent of police level officer is satisfied that such a crime is made out. Secondly, officers should record his satisfaction in writing that the offence involves Section 124A or the Sedition Act. So the officer now has to stipulate why, in fact, he is slapping 124A and how the crime satisfies the stipulations for booking people under the said act. What this does is it will prevent arbitrary use or misuse of this particular law. And satisfied that the government is now serious at the centre about modifying the provisions of Section 124A and giving it till the third week of July to return to satisfy the court. The court has passed certain orders today. Number one, the court has upheld the government's request for a relook at the law. So it has given it time. It has held in abeyance or stayed all those petitions that were filed challenging sedition law. Some of those petitions wanted it to be totally scrapped. Well, the court now has upheld the government's request for relooking at this law, and it also states some of those cases. There is no blanket ban on sedition law implementation. However, there are expectations from the Supreme Court that the government will be restrained in invoking the sedition law, government as in both at the centre and at the state level. The court has acknowledged, fourthly, the court has acknowledged the importance of rights and security balance, saying very clearly that they don't want at any level to compromise the territorial integrity or the security of the nation. And the court has said that cases where only sedition invoked to be kept in abeyance. So it is hoping that the government, where only sedition has been invoked, will be kept in abeyance. That is, hearings on those cases will be kept in abeyance. Appeals, if there are any filed, will be kept in abeyance. However, Kapil Sibal, who is a senior advocate and also a senior member of the Congress party, argued for the scrapping in the entirety, the striking down of the sedition law. The court has taken some exception to Mr. Sibal's point of view. When he said sedition law should be struck down, the court said, should we strike it down today? What is this argument? This is what Mr. Sibal was asked, prompted by the court. Then Kapil Sibal said, we never sought a stay on 124A. It only happened after they said they are re-examining. We want a complete scrapping. to which the Supreme Court said we are confronted with this yesterday and we were only considering an arrangement for the interregnum, which is in the interim, we are considering an arrangement. We are not looking at any level to push the needle on this and scrap the law. A little after the hearing, the Congress party viewers and other members of the opposition began to celebrate what they called was a historic victory for democracy and freedom of expression. Rahul Gandhi, I think, jumped the gun once again and said, speaking truth, not treason, but patriotism. Listen to truth, it's the state's duty. Where he got this impression from, viewers, we don't know, but he certainly made this statement. Randeep Surjewala, the Congress spokesperson and a leader, said, Congress vowed to scrap this law in 2019. SC, the Supreme Court backing our cause is a vindication. When the Supreme Court hasn't backed the Congress point of view in its entirety. D.K. Shivkumar, also of the Congress Centre, was using sedition as a tool, very quick to attack the government there. Nana Patole, another Congress leader from Maharashtra, says Centre was using sedition, misusing the sedition law, forgetting very conveniently that the Maharashtra government that he in fact, his party in fact supports, has just slapped sedition against an MLA and an MP that are independent. The Ranas are facing a sedition charge for insulting the denizens of Matoshri, viewers. That is, the denizens of the Chief Minister's residence. And the Supreme Court also acknowledged that that was perhaps overreach. Sitaram Yechuri of the CPIM came out and said the BJP is misusing sedition law, suggesting that the court had actually differed with the Congress and the BJP on this, and had actually intervened to stay the sedition law. Where they got this impression, difficult to ascertain, but viewers, perhaps they didn't read the order closely enough. The BJP slammed the opposition parties, in particular the Congress, for suffering from selective amnesia and for wanting to give a shield to India haters. A large debate has broken out. Let's open this up, viewers. Tonight, Sanju Verma, Ishkaran Bhandari, Sai Deepak, Ashutosh, Vikram R, spokesperson for the VCK, and Lokesh Jindal, leader of the Congress, are with us. I want to first begin with you, Sai Deepak. How do you read what transpired in court? Are you satisfied that this law must be read down and perhaps not scrapped, as the government seems to be wanting?
Basic points which must be understood. First, that I think the question of safeguards with respect to sedition and the manner of its invocation has been around for quite some time. So independent of dispensation, I think if the government has volunteered with certain regulations or certain practice directions to temper the manner in which Section 124A is invoked, I think it's a fantastic move. That's one. Second, you have to understand that there are certain significant overlaps between provisions of UAPA and Section 124A. Okay. Therefore, you may want to consider or reconsider whether you need both the laws. If yes, how do you justify it? But the larger question, which I think is the most problematic issue, is the Congress's objection to the concept of sedition itself being recognized by the law. Okay? And according to me, that is seriously problematic. I must say that anyone who's promising the scrapping of sedition as part of their election manifesto is catering to an anti-India base, according to me. And I'd like to understand, what is this vote base that you're catering to? What is this constituency that you're catering to, which is willing to lap up this kind of a serious anti-national sedition? Sedition is beyond politicization. Its unfortunate politicization must be tempered by courts. However, to say that sedition as a concept must be completely scrapped is problematic as far as Bharat is concerned, given the serious problems that we have, given the fifth columnists that India has become a breeding ground for. Therefore, as far as I'm concerned, the question of safeguards is independent and must be looked at differently from the question of whether sedition itself is required. If someone says you don't need to have both sedition under 124A of the IPC as well as the UAPA, I can still understand that. But if someone says scrap the provision under UAPA as well as 124 under IPC, then there is a serious red flag, pun intended, that has been raised.
Okay, so Mr. Sai Deepak almost echoing what the law minister said today, that there has to be a Lakshman Rekha. Sedition as a concept should not be scrapped. Let me bring in Lokesh Jindal of the Congress. Why is the Congress party so desperate in scrapping sedition as a concept from the law books? Sedition as a punishable offense, as a concept from the law books. Mr. Deepak says that this is being done because you have certain sympathies, or are you catering to an anti-India vote base?
Rahul, I'll just give you a historical context of this Section 124A. Now, this Section 124A was introduced by the British in 1860 and implemented in 1870. The colonial rule at that point of time was despotic. It was not a democratically elected government. And its implementation was mainly done so as to maintain the colonial character of the state. After India has become independent, although I understand that in the Kedarnath versus state of Bihar, the Supreme Court has underlined the necessity of such a law, but the character of Section 124A was against the democratic ethos of the state. Now it is a democratically elected government. The representatives are very much an instrument via which people can raise their voices. So there is no need for such a form of anachronistic and archaic or a despotic law at this point of time. Yes, in order to safeguard the sovereignty and the integrity of the state, there are certain laws that are necessary, but not a draconian law like that of Section 124A.
So you believe,
it is a welcome step.
So you believe, Mr. Jindal, it should not be applied, right?
Absolutely. That's a
okay, so let me ask you, the Ranas, there are a couple in Maharashtra. Now just correct me, because you see my sense of politics is just as bad as your understanding of sedition and its application in Congress rule states. So I just want to first have you correct me if I'm right or wrong on this. Does the Congress by any chance share power with the Shiv Sena in Maharashtra? I tend to forget these things. Do you or do you not?
Yes, we do. You do.
So how is it that at the center, Mr. Sibal and the Congress and the great Rahul Gandhi have a problem, a huge dislike of sedition law? But when Uddhav Thackeray's government, which you are a part of, you have told me now this, so there's no ambiguity about this, when they apply the sedition against the Ranas, you keep quiet. You don't criticize Uddhav Thackeray. You don't say, what are you doing? You're a despot in sheep's clothing.
The law was applied because it was there. The law was applied because it was there.
Oh.
I mean, there's no law of that particular form.
Okay, so when Mr. Gehlot, the other chief minister of Rajasthan, I hope he's still the chief minister. I don't know about the Congress there. Sometimes they, have an implosion, surprisingly. But you are right. Isn't he there? Mr. Gehlot is still there as chief minister. Even he applied the sedition law against some of his own. Was that also because it was there? He couldn't have picked any other law.
See, when we are talking about laws, that...
No, Jindal Sahab, I'm only asking you a simple question. You yourself said it should not be applied because it is despotic.
Cannot introduce reforms...
No, so then it should not be applied. There are hundreds of other laws, you will agree, isn't it? Which are overlapping. Mr. J. Sai Deepak himself has said there is a UAPA. You could have applied that. You could have applied any other law. You could have said public nuisance, disorder...
You want the government to tag everyone as terrorists?
No, I don't know, because Mr. Jindal, you seem to be wanting to tag only the Ranas who are your political opponents as terrorists.
So what you intend to say is everybody has to be branded as terrorists, whoever goes against the state?
Mr. Jindal, there are hundreds of laws which will serve the purpose. So I'm only asking you, why were you applying the sedition law when you have such an allergy to it? And why aren't you telling Uddhav Thackeray this?
Because when I'm talking about the Ranas, there was no need for them to come in front of Matoshri and recite Hanuman Chalisa.
Why, sir? What is Matoshri? No, what is Matoshri? Is it Mecca? No, what is Matoshri?
How is the sedition?
What is Matoshri? Is it the Indian state? It is the residence of the first family currently of Maharashtra. How is it the Indian state? Is Matoshri the Indian state?
It's not about the state or not, but there's
Look
a
at this
proper
guy.
occasion whereby religious...
Mr. Jindal, look at you. You are floundering tonight to sound coherent.
Absolutely
I mean,
not,
what are you saying? You are saying that if you stand in front of Matoshri and you chant the Hanuman's Chalisa, you are actually violating the territorial integrity of the Indian state.
What was the purpose underneath it? Was it being done to gain salvation? No.
It doesn't matter. I'm asking you, how is it an offense that should attract the draconian provisions of the despotic Sedition Law? Can you explain?
Because at that point of time, there was already a political issue of removing the loudspeaker that was going on. And at that point of time, the Ranas, they are simply, I don't even know if they know the Hanuman Chalisa correctly, but their overall objective was somehow to create some form of a religious code and destroy the...
So it's okay. So it's okay to apply the Sedition Law in a Congress-ruled state, viewers. Even though Mr. Gandhi, the revered Mr. Gandhi says speaking truth is not treason but patriotism, listening to truth is the state's duty. This is what he says, viewers. The Congress said, we vowed to scrap this law in 2019. SC backing our cause is a vindication of our stand. Yet, in a state, in multiple states where they are in power, they have slapped this. Chhattisgarh, Jharkhand, Rajasthan, everywhere they see seditionists, viewers, but they don't see them in the Supreme Court. That is really bizarre. It is bizarre. Nonetheless, Sanju Verma, would you like to respond to Mr. Jindal? And I have a question for you also. If there are other laws, why do you need the Sedition Law? Other laws serve the purpose. Is India's territorial integrity so brittle that a few stray words by a bunch of misguided individuals will affect us? So just explain this, because that's the question that a large number of people will throw at you here tonight.
Thank you, Rahul. You know, I'm familiar with the concept of master of ceremonies, but I think today, in your rebuttal to Lokesh Jindal, Rahul, you proved to be the master of sarcasm. Let me make some moot points. Rahul Gandhi today has tweeted, "Sach bolna, desh bhakti hai, desh droh nahi, sach कहना देश प्रेम है, देश द्रोह नहीं." I completely agree with him. But look who's talking, the pot calling the kettle black. First, let me just educate Mr. Jindal. Forget Navneet Rana and her the time being. Let's come straight to the point. Sedition law came about in 1870 to ensure that there were relevant curbs on freedom of speech and expression. Now, who passed the First Amendment? It was passed in 1950-51 by Jawaharlal Nehru. Who passed the 42nd Amendment, which restricted the power of judicial review of courts? It was done by Indira Gandhi in 1976. I'm not even talking about the draconian NISA and the emergency imposed by Indira Gandhi. Who tried to pass the anti-defamation bill? That was again done by Rajiv Gandhi, though he was not successful at that. Who brought in the draconian 66A? In 2008, it was none other than Kapil Sibbal. Same Kapil Sibbal, today the father of 66A, says that throw sedition out of the window. It's like saying throw the baby and the bath water out, which is not possible. I will simply say this, that Congress is the last party which should wax eloquent. There has been a lot of debate that all parties are saying BJP utni hi buri hai jitni Congress hai when it comes to slapping sedition charges. That is an argument that I want to rebut with statistics. On Times Now itself, the data has been shown that between 2014 to 2019, 326 sedition cases were slapped by the Modi government. In 2012 alone, when the Congress was in power, 9,000 sedition cases were slapped in a single year. 56,000 people were detained arbitrarily, and 23,000 people were arbitrarily arrested in 2012. So don't make this false equivalence between the BJP and the Congress, point number one. Point number two, I think the moot point to be noted, and what J. Sai Deepak has also alluded to, the Supreme Court down the very relevant Kedarnath Singh versus the state of Bihar judgment pertaining to 1962. It has upheld the central government's desire to have a review and bring about necessary changes in the sedition law, which will then be heard in the Supreme Court in July. Supreme Court has also said, exercise restraint, but it has not told the center that don't invoke fresh sedition charges. All it said was, we expect the center to be restrained. So by and large, the Modi government stance has been vindicated by the Supreme Court. And let me tell you this, that Prime Minister Narendra Modi is the biggest champion.
No, that's fine. I just want to ask you, Ms. Verma, I just want to ask you, that's all very well. That's all very well. But why not move to a space where you completely scrap it? After all, there are other laws which serve the purpose. You didn't answer that question.
Okay, Rahul, 10 seconds. That's a valid question. I'll just say this, that the reason for not scrapping sedition altogether is completely, maintained in the argument given by the Union Law Minister when he was asked this question. He said, while we respect the values enshrined in the Constitution, we value at the same time the unity, integrity, and sovereignty of India cannot be compromised. So there has to be a fine balance in the trade-off between free speech and national security, a fine trade-off between free expression and territorial integrity. Let's not try and conflate the two. Let's maintain that fine balance, and that is the reason sedition law needs to be there, but to be exercised with restraint.
Let me get...
Can I reply?
No, one second, Mr. Jindal. We had a long conversation with you. You've caught yourself up in a huge bind. So let's go to the others who might take a clearer position and have the courage of conviction to take that position. Let me bring in the VCK's Vikraman R. Mr. Vikraman R, simple question to you. This government says that when you scrap this particular law, you end up emboldening India haters. Why would anyone want to do that? How do you respond to them?
Okay, first of all, why these sedition charges are pressed against some 3 Kashmiri students who were celebrating the victory of a Pakistan cricket player? Is that a sedition which we are talking about? And the sedition law is highly abused and misused by this BJP government against the minorities especially, and the newspaper journalists who are actually bringing out the corruption charges against the BJP rulers. So this is the point which you are trying to make. See, sedition.
Are you saying it's only misused by the BJP government? No other state government misuses them? No other opposition party misuses them?
You have brought in some instances where it is used in Rajasthan, Chhattisgarh and Jharkhand and all. You have brought in some instances. I appreciate that. And even in Tamil Nadu also, it has been used in the past, but not now. After the DMK had taken power, it is not used. But we, time and again, have been...
When was the last time it was misused in Tamil Nadu? Can you tell me that? And was it not... you were part of the protest then at Kudankulam. And I believe that at least 6,000 plus people were booked.
7,000.
7,000. Okay, I'm corrected here. 7,000 plus people were booked in one go for sedition. I don't know if one of you were there and maybe you might have been booked. I don't know about that. You can tell us if you were. At that point, I didn't hear you saying that it was just the BJP government. That was, of course, a Congress government, if you remember, or at least a coalition government.
No. I think you are referring to an AIDMK government. AIDMK government was not in coalition with Congress or BJP.
No. I'm talking about the fact that the UAPA, the UPA was there in power at that time.
UPA was there, but the sedition case was filed by the state government.
True, but they didn't make such a big agitation out of it, did they?
Since IPC is in the concurrent list and any government can...
Mr. Vikraman, I understand that. I'm saying that it happened under the aegis of a central government, right, which was run by the Congress party, right or wrong?
It was run by the Congress party, but you cannot blame the Congress party for it. It was pressed by ADMK, right?
That's
ADMK
true.
was not in the coalition.
So
Why is she laughing?
The Congress,
I don't understand.
The Congress kept very silent. Should they have kept silent?
No, they were in the opposition. ADMK was not in the coalition. They were in the opposition gang. And see, if the sedition was filed in Maharashtra, should BJP be blamed for it? because BJP is in the union government? No, right? It is like, they are in the opposite camps. How can Congress be vocal about it? See, now the Congress president has expressed his view that the sedition has to go. This has been time and again, we are pressing that demand. So now the Congress has taken that stand. Let us welcome it.
Okay. Ishkaran Bhandari, respond please. What's your take on this?
Rahul, firstly, views in opposition are cheap. Action in governance is priceless. The Congress spokesman started by history. So I would tell him history. It's become very fashionable to say this law is colonial, it needs to be done about it. Our entire Indian Penal Code is colonial. It's 1860. All the laws, most of the laws in India are colonial. We can't cherry pick, this is colonial, so it should go, this is not colonial, so it should remain. And now coming to this law, let us be very clear. The very first amendment brought in by Nehru government, which Shyama Prasad Mukherjee had opposed and said, you are using the constitution as a scrap of paper, came because Nehru on the floor of parliament said, what the press speaks will corrupt the morals of the people. So from the very beginning, the first amendment of Azad Hindustan was to curb press, to curb people who speak. Majroo Sultanpuri, for a mere poetry of saying Commonwealth ka das hai Nehru, spent 1 year in jail, and they talk about artistic freedom here. But let us come to the specifics also. Please don't interrupt, I didn't interrupt you. Let us come to the specifics also. I believe it is a fight of citizen versus government. All governments abuse it in power. Everybody will give instances of all political parties. But in this instance, if BJP has taken an enlightened stand and the Supreme Court, in a very short order, paragraph 4 and paragraph 5, has said the central government has prima facie agreed with the view of the Supreme Court. The Supreme Court order itself gets strength from the affidavit filed by the government and quotes it. Then that shows in power this government is taking a very constructive stand so that citizens have more right to free speech. Obviously, the exception, I am generally very wary of giving government the power to put people in jail for speech. But just one speech, Sharjil Imam, if he says, 5 lakh log ikattha kar lo, chicken's neck pe ikattha kar lo, it's a narrow corridor, और हम इंडिया से permanently उसको तोड़ देंगे, नहीं तो कम से कम कुछ महीनों के लिए तोड़ देंगे. Now, how is that not an offense in a speech where you are asking 5 lakh people or 2 lakh people to come to a narrow corridor to dismember India? That, of course, has to be an offense, whether it's read down under some other name, whether it is under UPA or any other category, that has to be punished. So people who are inciting dismemberment of India, making a plan, saying these many lakhs of people reach this strategic point, so we do it, that has to be punished.
Okay.
Can I reply, sir?
Yes, yes, of course.
Please. First of all, let me correct you. When we are talking about first Constitutional Amendment Act, then please understand the context within which this Amendment Act was introduced. In 1948, after Gandhi was assassinated by Nathuram Godse, RSS was banned.
No.
And the ban was...
No. Your history is completely wrong. This had something to do with Bihar. This had something to do with Bihar.
No, let me just point it out. Let me just.
No, this had something to do with Madras.
No, this is atrocious. Unbelievable.
It was something to do with STL Madras, but the fact remains the same that Nathuram Godse killed Mahatma Gandhi. Nathuram Godse belonged to RSS.
It's got nothing to do with Mahatma Gandhi and RSS.
Rahul is just factually wrong. He's just lying.
This is unfortunate.
Let me quickly read out the facts. The tussle began. Mr. Jindal, you probably don't get this right. The tussle began in March 1950, when in response to severe criticism in the press about its response to the refugee influx in West Bengal and extrajudicial killings of communist activists in Madras, not RSS, sir, communist activists, some of your best friends. Okay, the government attempted to censor. Sir, please. Mr. Jindal, look, you can't be the fount of all knowledge. There are 5 people, including the VCK spokesperson, who's disagreeing with you. So get your facts right. You can always come back to these debates with your facts right. You'll cover yourself in glory. You'll make, stronger arguments. Let me bring in Ashutosh. Ashutosh, what's the issue here? Sedition, by its very nature, obviously poses a threat or arouses a threat against the Indian state, in principle, says J. Deepak, we should not completely scrap it as a concept. It should be retained. You can debate whether it should be under Sedition 124A or it can be UAPA or whatever. You can come up with a nomenclature and different name, etc., etc. But as a law to punish those who are India haters, splittists, separatists, etc., it must be on the books. Ashutosh ji. I can't hear you, sir. I think you muted yourself. Yeah, please. Yeah.
Rahul, I think the first, this impression should not be carried from your discussion that the Supreme Court has put in abeyance the entire sedition law. It has not.
Yes, it
has. It has
hasn't.
only put in abeyance Article 124A. Why it is so? Because Article 124 has been a contentious, a complex issue since 1951. If you remember, in 1951, the Punjab High Court has invalidated this 124. In 1952, the Bihar High Court validates it, and in 1956, Allahabad High Court again invalidates it. Then in 1962, the Supreme Court decides it does not, it did not invalidate Article 124A. It simply puts that in what conditions this 124A should be applied and applicable. Now, why it is so contentious? For the simple reason, because if I say something, can that be amount as a waging war against the state? No, it should not. And that's why the Supreme Court has made it very clear. In Balwant Singh case, even somebody is raising a slogan like Khalistan Zindabad, does not amount to waging war against the state. The Supreme Court is very clear on that point, that it has been misused. And since it has been misused, so it should not have place in the modern civilized society in that sense. And I think Supreme Court, and within the Supreme Court today in the hearing, Tushar Mehta was quite insistent that this law should continue, and that's why he suggested that then an officer of the SP rank should write, and he should be satisfied. That means the central government was insistent that this law should continue. So if anybody is saying the central government wanted this law to be discontinued, I think it's not factually correct if one goes by Tushar. My submission is very clear. This law should not exist in our dictionary, and because it is a fetter on the freedom of expression.
Okay, so Ashutosh ji, couple of factual problems with your response, and I have the Supreme Court order right here in front of me, and I'm going to quote out of it. And this is important. So the government has not said at all that it is opposed to a review or re-examination of 124A. In fact, it says we are in favor of that. And they have put down an affidavit that was submitted a couple of days back by the MHA, quoting the Prime Minister's desire to do away with certain laws. And let me quote, the Prime Minister believes that at a time when our nation is marking Azadi ka Amrit Mahotsav, we need to, as a nation, work even harder to shed colonial baggage that has passed its utility, which includes outdated colonial laws and practices. In that spirit, the Government of India has scrapped over 1,500 outdated laws since 2014-15. It has also ended over 25,000 compliance burdens, which were causing unnecessary hurdles to the people of our country. Various offences that were causing mindless hindrances to people have been decriminalized. This is an ongoing process. These were laws and compliances which reeked of a colonial mindset and thus have no place in India today. The Government of India, being fully cognizant of various views being expressed on the subject of sedition and also having considered the concern of civil liberties and human rights, while committed to maintain and protect the sovereignty and integrity of this great nation, has decided to re-examine and reconsider the provision of Section 124A of the IPC, which can only be done before competent forum, which I presume is the Parliament. So there is very clearly written there, re-examine and reconsider. Secondly, the Supreme Court, sir, give me 30 seconds. The Supreme Court in clause 5, page 3 says, in view of the above, it is clear that the Union of India agrees with the prima facie opinion expressed by this court that the rigors of Section 124A of IPC is not in tune with current social milieu and was intended for a time when this country was under the colonial regime. In the light of the same, the Union of India may reconsider the aforesaid provision of the law. So it concedes. The Supreme Court, this bench, concedes that the government in clause 5, page 3, it orders that it is clear that the Union of India agrees prima facie with the opinion expressed by this court that the rigors of section 124A is not in tune with current. So basically, sir, what you are saying. So the government has not said we don't want to in any way relook, re-examine this particular law. So on that point, sir, you stand corrected. Secondly, sir, let me just finish. Just to make this clear, the Supreme Court has not held in abeyance, has not stayed sedition.
Exactly.
On page 4.7, it says, therefore, we expect that till the re-examination of the provision is complete, it will be appropriate not to continue the usage of the aforesaid provision of law by the governments. The word is expect, not that we order. If it had been therefore we order that till the re-examination of the provision is complete, it will be appropriate not to continue the usage. It says we expect, and it goes on to say later on, clarifies, and let me read this to you very, very clearly. We hope and expect, clause B of point 8, page 4, we hope and expect that the state and central governments both will refrain from registering any FIR, continuing any investigation. We hope and expect. Yes. It doesn't say that we order. So there is no abeyance of the sedition law. Yes, sir.
Exactly.
See, I think if you read what Tushar Mehta has said,
no, I'm only reading, sir. Forget Tushar Mehta. I'm reading out the order.
I'm reading out what the Tushar Mehta has said in the court during argument. He said we are dealing with a cognizable offence which is upheld by the Constitution bench, and we are considering an interim arrangement. In that context, first, we do not know the gravity of each of the offence pan-India. There may be 124A along with other offences. Laundering may be some terrorist angles, so many angles, we do not know what situation and gravity. He has not said in the court of law that government of India intends to scrap this law.
Of course, they don't intend to scrap it. No. Ashutosh, they don't intend to scrap it. They are saying that we are open to reworking, re-examining, not scrapping. You're on the wrong debate. The question, therefore, I'm posing. The question, therefore, I pose to Jai Sai Deepak is whether it should be merely reworked or it should be entirely scrapped. And he believes that sedition as a concept must not be entirely scrapped. Jai Sai Deepak, am I right or am I wrong? Am I misquoting you? Please tell me.
No, you're 100% right. That's exactly the position. So, see, the question is simply rationalization and safeguards, nothing beyond. And the best part is, on sedition, you have committee reports which clearly show that it's not as if the concept of sedition is not to be found in the statute books in other jurisdictions. It is present in other countries as well, the so-called civilized countries, the first world countries, and these advanced jurisdictions that we constantly look up to on both sides of the Atlantic. They have laws with respect to this. In any case, please understand one thing. Anyone who says that this is a colonial legislation, I'm sorry to say, is completely ignorant of the history of this particular legislation. Section 124A, Ashutosh ji, it's not Article 124A. Section 124A was the specific subject of discussion during the Constituent Assembly debates. And there are debates of Kulapati K. Munshi, where he clearly says that although this is a colonial legislation, the fact of the matter is over the years, thanks to British court judgments, the rigor has been reduced significantly and it has become consistent with the principles of free speech enshrined in the Constitution of Independent India. Therefore, Section 124A was retained by the framers of the Constitution with the clear knowledge that the original position of 124A when it was introduced in 1870 is very different from what it was applied in 1940s. And one final clarification, this needs to be busted. The spokesperson from the Congress is completely, glossed over the history. It was not introduced to go after freedom fighters. Colonial legislation, which is to say Section 124A, was introduced to go after the Wahhabi movement in 1863 and 1870, not against independence movements such as the Congress. So please get your facts right.
Well, that's a problem at this moment with the Congress. Yes, Sanju, very last, yes. 30 seconds, please. Go ahead.
Rahul, I have always told on various subjects on your channel that the crux to any controversial issue is a sense of proportion. As Mr. Bhandari said, when Sharjil Imam said, cut off chicken's neck, or strip out Northeast from the rest of India, it comes under the ambit of sedition because you're questioning the territorial integrity of the country. When Vinayak Sen openly says that I support Maoists and Naxals, that comes under the ambit of sedition. When Sudha Bhardwaj, Vernon Gonzalez, and Gautam Navlakha say we support Naxals at Jima Koregaon, that comes under the ambit of sedition. But when Uday Kumar, an activist, says I am against the nuclear power plant coming up in Kudankulam, that is not sedition. So let's have a sense of proportion, and that is precisely
But Sanju Verma, you will appreciate on that point. Yes. You know, it's all very well in theory, but the BJP has also applied sedition to muzzle free speech and has been ticked off by the court. So I'm glad, however, that the government at the center has realized that this is open to misuse. And I have a whole list of those instances also when the BJP has misused sedition.
You can be generous to the BJP sometimes.
No, I'm generous, ma'am, to the truth. You know me. I don't mince my facts. The facts are there. All political parties in this country, unlike what the VCK spokesperson seemed to suggest at the very beginning that only the BJP, etc., all political parties, without exception, have used sedition to go after their opponents. So, as long as we understand that, and then we bring in safeguards, as J. Sai Deepak and Ishkaran Bhandari have advocated, we are fine. We must acknowledge that there has been misuse.
I want to bring in some facts about this.
Okay, sir. Go ahead.
Okay, see, between 2016 and 2019, the number of cases filed under Section 124A rose by 160%. You know which rule is it? It is BJP rule.
Yeah, but you yourself said that a large number of state governments don't report to the BJP also where they have used this. So all governments have used it. That's the point I'm making.
Going by your facts, you were asking me about the Kudankulam issue.
Well, that's what I was saying to you.
Issue was happening in the ADMK government.
That's what I was saying.
You wanted the Congress Union government to respond to it.
But
I am saying,
sir, you have your political...
2016 and 19, Union government was BJP.
Mr. Vikraman,
the cases against sedition was...
Mr. Vikraman, look, you have your political...
Sedition charges against Maridor.
Rahul.
Who slapped sedition charges against Maridor? The
Pardon me?
spokesperson. Who slapped
Maridas was inciting violence against
Did you not
Muslims.
slap
He was equating our chief minister to somebody from...
yes or no?
Yes,
yes
somebody from
no?
Islamic terrorism. What?
So stop giving...
See, are you allowed to incite violence between two communal groups?
See, now comes the nub of the issue.
Are you allowed to incite violence between two communal groups openly?
So that's what... So the VCK spokesperson...
You have
Sir,
no answer.
Okay, yes. See,
I
viewers,
am having answer.
when you ask the
I'm answering
VCK
you.
spokesperson, he says it's okay. In the instance where we are the affected party,
Yes.
it is okay in this particular case. That's right. So I'm saying so, sir, to you. No, one second. Even in the communal violence incident, sorry to say, even in communal violence, it is not sedition. You could have gone
exactly. It's 153A.
It's 153A.
Yes.
So, Mr. VCK spokesperson, Mr. Vikraman.
Rahul, let me complete. She was asking me why the case was slapped against somebody from our state. I was explaining why it was slapped. I was saying the grounds for the slapping of this case.
Do you accept it?
And I'm not for it. I am
You're
not for it.
Good. I'm glad because you just revised your statement.
General sedition, I'm not for it.
So viewers, look at this. Here is the situation. All political parties, when it serves their interests, support sedition cases when they are slapped. The basic point here is the Congress, the NCP with the Shiv Sena, hounding two independent MP and MLA couple, the Ranas. Go after them, it's okay, because you see they stood outside Matoshri and wanted to, they didn't even get there, by the way, so there was no offense committed, but nonetheless, the intent of standing in front of Matoshri to sing the Hanuman Chalisa became problematic. Not the action.
Ridiculous.
I mean, it is so out there,
Rahul,
the application. Yeah, but sir, there are many other laws. They didn't even do it.
Yeah, there are many other laws, but
Yeah.
BJP is using it against the minorities, using it against
No, you might be,
intellectuals,
sir, you
using
might
it
be
against the
right.
liberals,
You might be
using
right.
it against
But what my
opposition
point is, are
parties.
you going to disagree
So
with
let
my
us
basic
scrap
point?
it. Let us scrap it. If you say
Mr.
the
Vikraman-
opposition is also using it, now we are saying let us scrap it. What is
Mr.
the problem
Vikraman.
with the government now?
Mr. Vikraman, I am not defending the
yes.
government. I have actually written in the Times of India calling for the scrapping of this god-awful law.
Exactly.
So I
I'm
think
talking
you
to
and
the
I are on the
government
same
only, not
page.
talking
But
to you. I'm asking the government only.
No, I know exactly what you're asking, but I just want to bring it back to the basic point that we have at least recognized the need now to bring in some sort of filters so that it is not misused. That's a step in the right direction. Whether we go for full scrapping or not, that was the debate that we were having. Some people say that no, as a concept it should still exist and therefore it should be on our books, albeit in a manner that it cannot be open to misuse, straitjacketed. Others are saying it should be scrapped. Because you can choose your point of view, but I just want to say all political parties misuse this. The time has come when we put fetters on it. I want